morning, everyone. Welcome to Cornell Cooperative Extension. I'm Mike Danaher. I'm an Assistant Attorney General with the New York State Attorney General's Office. I'm here to present our monthly Consumer Issues program. Today's topic is a big one, and I say big because it's a topic that our office receives a considerable number of questions about on a daily basis. We also receive a vast amount of complaints regarding the topic of landlord and tenants' rights and responsibilities. Our goal here today is to just discuss what the rules are on both sides. We keep it pretty level. We don't emphasize landlords or tenants. We just explain what the rights and responsibilities are of the various parties so that people going forward can better understand what their rights and responsibilities are as it relates to landlord-tenant situations. And I know that's really appropriate here at Cornell Cooperative Extension of Tompkins County because a very, very large percentage of housing in Tompkins County, I've heard somewhere in the neighborhood of 70%, is rental type housing. So it's good for all the landlords and all the tenants to know what their rights are as well as their responsibilities, and there are responsibilities on both sides, so that people know what to expect going forward. The way I always like to start these talks out is to discuss what the whole foundation of this relationship is. And what it is that it is simply a contract. It's simply an agreement between two parties to enter into rights and obligations on both sides. On the landlord's part, the landlord is giving up his or her use of the property for a designated period of time to a tenant who is receiving the right to exclusively use this space. So it's just a contract. It's with a contract, not to get into too much of the weeds of law, but I am a lawyer, so is that for a contract you have to have certain fundamental things: an offer, an acceptance, and consideration. An offer can be made by a tenant or a landlord. That's making the offer for, in this case, the residents. We'll use residents. We're not going to talk about the commercial leases, but equally true in a commercial lease situation. Is that somebody makes an offer: I'll rent this place for X number of dollars a month, or I'll let you rent my place for X number. And then there's acceptance. There has to be an acceptance on the other side. So it's the tenant saying, yes, I'll do that, or the landlord saying, yes, I'm willing to let you live in this place for X number of dollars. So we have offer, acceptance. So then we need consideration. We need something passing back and forth that the other party does not necessarily have any legal obligation to do. And that consideration is very simple in a landlord-tenant situation. Is the landlord is giving up something. That's something of value. It's giving up exclusive use and occupancy of the space that he or she owns. And the consideration that the tenant is giving is the promise to pay for that space, as well as other incidental promises such as to keep the property up and that sort of thing. So once we have offer, acceptance, and consideration, we have a contract. And when I ask somebody, do you have a lease? The first thing that people think about is, do I have a written agreement? In some instances, they don't. But what I'm talking about from a straight legal perspective is, do you have an agreement? What's the agreement, the lease? It could be oral, it could be writing. But what is the agreement do you have? So do you have a lease? And the answer is yes, because you wouldn't be living there unless you did. But they always say, no, I don't have a lease. Well, what they mean is I don't have a written lease. You can actually have a contract for residential property that is not in writing. The law provides in New York that any contract that can be completed in less than a year or less, does not need to be in writing to be enforceable. Okay? That said, forget what I just said. It is crazy from both perspectives the tenant's perspective and the landlord's perspective to go into this relationship without having something in writing. It is just a fertile ground for problems. Get it in writing. Now, the tenant could say, well, you know, I don't want to be tied down to rent a place for a year, and I want it to be more flexible because I can give a whole host of reasons. So let's use one. I'm looking at buying a place, and I might be in that place in a couple of months. I don't want to be tied down to a year or anything like that. That doesn't mean you don't get it in writing. You can still get it in writing. Landlord side, landlord says, you know, I don't want to be tied up. I may have a family member moving back to the town in the near future in the next couple of months. I don't want to be tied down because I want to have a place available for my friend, my family member, whatever, to move in, so I don't. Get it in writing. You can still have an agreement for a shorter period of time than a year. You can have a written agreement month to month that could just continue to go on. Get everything in writing. It solves so many problems if you get it in writing. Now, if it's a lease for longer than a year, it must be in writing to be enforceable. But regardless, get it in writing. It's so much easier to resolve these things because if somebody says, well, you know, I brought my dog in, and the landlord never said anything about not having a dog. And the landlord then comes in and says, I never allow dogs in my apartment. He never asked me to have a dog in there. It's not allowed. Well, if you had it in writing, if a person goes to bring a dog in, both sides can pull out the paper, the lease, the written document. It says, no pets allowed. There's the answer. So if the tenant is thinking, you know, landlord never said anything about a puppy, and I saw this cute puppy. Looks like it's just the nicest thing in the world. Nothing was ever said, so I'm going to bring it in. If the tenant had it in writing and pulled it out and it says, no pets allowed, there's the answer. They won't be calling our office saying, you know, we have an oral agreement. Landlord never said anything about pets, and I want to bring a dog in, and the landlord's now coming to me saying, get that dog out of here or move out, but he never said anything. And the landlord says, but he never asked. And then we get that whole he said, she said kind of thing. Get everything in writing. It solves all the problems. So the laws related to leasing, residential leasing, are all over the place. It'd be nice to be able to pull a book off the shelf or have somebody call me and say, hey, where is it in the law about this, that, and the other thing about security deposits or all this stuff? And it'd be great for me to say, well, there's a book, and you can go look it up. Well, we have laws that touch on the landlord-tenant relationship, but they're not just in one book. We have these volumes in our office of all the statutes, which are the laws that are adopted by the legislature. And it fills a whole wall. And there's probably, I'll take a guess, there's 150 books of different, maybe more, I don't know. And in it there's the A's, starting with alcohol beverage control law kind of stuff, down to, I don't know what would be at the end, Z. Usually zoning is not a, usually that's a local issue, it's not a state law. We have all kinds of books. Down toward the end is the S's, the Surrogates Court Procedure Act. So there's all these books. And in different ones, there are different issues touching on the landlord-tenant relationship. It's contained in the real property law, so we have an R for the real property. We have the general obligations law, that's up in G. We have the RPAPL, which is the real properties, actions, and proceedings law. That deals with the procedures for evictions. It could be involved in the multiple dwelling law. They're all over the place. So it isn't just in one location. Our office does have a booklet, which I encourage all of you to look at. It's called the Tenant's Rights Guide. Throughout the years, many have come up to me and said, well, that's the Tenant's Rights Guide. Where's the Landlord's Rights Guides? Well, that's all in there because it just lists everybody's rights and obligations in there. It used to have a really long name, but we cut it we cut it down, and so that's available. And it's available on the Attorney General website at www.ag.ny.gov. So it's attorneygeneral.ny.gov. So it's ag.ny.gov. And you can go there and look up consumer-related issues, and in there we'll have our tenants' rights guide under housing issues, and it'll give you some information that we're talking about today. It does include, just as kind of as a caveat, it does include some issues related to housing in New York City, which only applies in New York City. They have special rules, they have rent controls and things, which is not upstate in this area. But it's a good place to look if there's a question related to the tenant-landlord relationship. So let's talk about what are the rights and responsibilities of the parties associated with this. We have two parties. We have a landlord, we have a tenant. What are the landlord's obligations? The landlord's obligation, main obligation, is to provide a habitable residence that does not foist upon the landlord the obligation to give the Taj Mahal. It just has to be livable, safe, and sanitary. Doesn't have to have air conditioning, doesn't have to have all new carpeting and all new flooring and all new cabinets and all new appliances. They just have to be functional. As long as the items are functional and livable, then the landlord has met his or her obligations. Those obligations would include to provide heat and water and hot water. It does not mean that the landlord has to pay for it. If the agreement between the parties is a set amount of rent, and then that the water bill is in the name of the tenant, or the heat has to be in the name of the tenant, as long as that is in what the parties agreed to, that is all that the responsibility is. Now, the functional delivery of those items is the landlord's responsibility. For example, if the furnace breaks, it's the landlord's responsibility to fix it. If the water stops flowing, not because the tenant didn't pay the water bill, it's the landlord's responsibility. If the hot water heater goes, it's the landlord's responsibility. So the landlord is under the obligation to fix those sorts of things. The landlord, it's often asked,
these are all in residential, doesn't apply to
the question was, this is all in residential, doesn't apply to commercial. Generally speaking, in commercial leases, the agreement between the parties is what governs. And in a lot of commercial leases, there'll be things called a triple net lease, which means that the tenant is responsible for all the expenses associated with it, repairs and insurance and certain other things, taxes possibly. That's all governed by the written agreement, and we're thinking that in most instances the commercial tenant is a business person and much more sophisticated in negotiating these particular contracts. In the tenant situation, it's the landlord's obligation to provide what the landlord has agreed to provide, and that is a livable residence. If the furnace breaks, if the stove breaks, if the microwave breaks that is part of this transaction, it's the landlord's obligation to fix. The question comes out is, how long does the landlord have to fix it? And there is no definitive time period other than it has to be within a reasonable period of time. And the best definition of that is, landlord, if it was your house, how long would you take to get these things fixed? And I think in a lot of instances, most reasonable people can agree on how long that might be. The landlord, because the landlord is not living there, can't just sit on his or her hands and say, we'll get around to it. If you were living there and you didn't have a stove, how long would it take you to get those things fixed? And that should be a good governing period. What can the tenant do if the landlord doesn't provide what the landlord is obligated to provide. The landlord is getting paid rent. And so the cost of fixing these things is a cost of doing business and has to get that fixed. The tenant could, one, if the landlord doesn't fix it within a reasonable period of time, another function of the contract law is, or principle, is that if either party breaches a contract, that absolves the other party from having to fulfill their obligations. So if a landlord breaches, doesn't fix the hot water heater within a reasonable period of time, that absolves the tenant of their obligations under the lease, meaning to pay the rent, to continue living there. The tenant can move out without any further obligation to the landlord financially. That's why it's incumbent on landlords to get these things fixed and get them fixed within a reasonable period of time. The tenant could also ask for a reduction in the rent, or what we refer to as a rent abatement, for the value of the loss that they sustained. I've had situations, and again, some of these areas are gray, they're not black and white, but let's assume that the tenant rents a 3-bedroom apartment and pays $1,000 a month. And for some reason, heat is not working in the bedroom, or there's water infiltration and makes it not able to be lived. So the 3rd bedroom is offline, so to speak. The tenant's not getting what the tenant agreed to receive. And the landlord can say, well, you only have 2 people living in the apartment, so you got that 3rd one. The tenant rented a 3-bedroom apartment and should have use and occupancy of that. The question comes down to is what's the value of that 1 bedroom? And that's not a question for me to answer. That would be a question, frankly, for the court to answer, as to what that value is out of the $1,000 rent for not use. But there is a component there that the tenant is not receiving $1,000 worth of value because they rented the whole place for $1,000. So there could be a potential for a rent abatement or a reduction in the rent due to not getting everything that the tenant agreed to receive. What should a tenant do in that situation? What the tenant should do first and foremost, sometimes this is very difficult for tenants. Call the landlord. Put the landlord on notice. If it's a big thing, what I usually recommend is you give the landlord written notice and keep a copy for yourself so that you have. Nowadays in the high-tech world and they're texting and all that stuff, keep a copy of the text messages going back and forth as to when notice was given. Landlords, same with you. Keep a record. Keep a record of that text message as to when you received it. Keep a record of all the steps that you took to try to correct it. Call the heating guy the X time. Call the heating guy at this time. Call the heating guy at this time to get him out. Called another heating guy because this guy didn't get back to me. So you can keep a record of the reasonable steps that were undertaken in order to correct that problem. In an emergency, we talked about, landlords have a reasonable period of time to correct a deficiency. And reasonable is a really good term to use. I do frequently and jokingly say the term reasonable is what lawyers get paid a lot of money to define. But in most instances, I think that we can agree within a window of what a reasonable period of time would be. And it would be so much easier for everyone if they just would say, I have 72 hours to fix it. I have 48 hours to fix it. But let me ask you, if it's July and the heat goes, is 48 hours a reasonable time? You could fix it a month from now and not have to worry about the heat. It's January 1st and the heat goes. Is 48 hours enough reasonable time? No. You got to get on that right away. So it's a reasonable time, and it fluctuates to what reasonable people would believe over that period of time. If there's an emergency, let's say the heat goes out on January 1st, and the landlord gets contacted and no repairs get made within a reasonable period of time. I would encourage the tenant to keep contacting the landlord and say, hey, it's been a couple hours, it's getting really cold in here, and a couple hours after that, hey, it's really, really cold in here. If this doesn't get taken care of right away, I'm going to have to go out and get somebody else to do it, and the landlord doesn't get back to them, the tenant would be within their rights to go out and have somebody come in to fix the problem. And in that case, the tenant would have the right to have the repair made and deduct the cost of the repair from the rent. Again, have good records as to what was done, what steps were taken, so that if at the end of the month or the start of the next month, it cost $500 to fix, what I would encourage the tenant to do is to say, here's your check for $500, and here's the receipt for the $500 that I had to pay to have the furnace fixed because it wasn't fixed. Then if the landlord says, you need to pay me the $1,000, you owe me $1,000, I will evict you, the tenant can say, go ahead. So then the landlord goes to court to try to evict the tenant for only paying $500. The tenant can say, I paid the rent. And the judge will say, well, I only have proof here that you paid $500. Yes, but here's a copy of the repair bill for the furnace because I notified the landlord at this time, and this time that the furnace was out, and he never got back to me. And I had to go out and have it done myself. Here's a copy of what I had to pay. The two added up to $1,000. That's the rent. I paid it. The judge then looks at the landlord and says, huh? And the landlord would have to explain him or herself as to why it took them so long to handle it. I am not an advocate of using rent or holding rent as hostage. Say, I'm not paying you a dime until you fix this. The concern being is, let's take the scenario you were using. Let's say that it will cost $500 to have the furnace fixed, and you're not paying $1,000 worth of rent. You run into the possible situation, I'm not saying it's going to happen, but you run into the possible situation of the judge saying, yeah, but it would only cost you $500 to fix, and you didn't pay anything. You owe $1,000. You didn't pay your rent. And we'll get into it in a few minutes, but the outcome of not paying your rent and going in front of a judge and the judge deciding, yes, you did not pay the rent, is a warrant for eviction, and you'll have 72 hours to get out. So I say cover all your bases, find out how much it costs to fix, and then you can say, okay, I paid you $500 this month because I know it's going to cost $500 to fix. I didn't pay the extra $500. If you're not fixing this, I'm paying to have it fixed. Now, some judges may be sympathetic. If you don't have heat, you don't have heat. It's incumbent upon the landlord to get the thing fixed. If the landlord doesn't use his or her power to find somebody that's going to find the cost of getting it fixed, then the tenant not paying the rent. It's really a hard argument for a landlord to go to a tenant and say, pay me my rent. You owe me $1,000. And the tenant says, I don't have heat. When are you getting me heat? And the landlord's saying, I'm not giving you heat until you give me the $1,000. I think the landlord's going to lose that argument. So there's some wiggle room there. I think the best bet is don't hold it hostage. Figure out how much it's going to be, and then you've got a really good argument to make when it comes to court. The other thing that a tenant can do, and I encourage them to do that, is call code enforcement in the municipality in which the residence is located. Call code, I don't have heat. There are certain minimum standards that a property must be up to. there's no set rule as to what those minimum standards are, but I do think a good rule of thumb are code standards, because those are kind of minimum standards that must be met. There are certain things that code does not cover, like mold. But there's certain levels. I mean, you have to have heat. It's got to be safe. And code has the enforcement powers of being able to punish landlords that are not keeping their property up to code. Certain things are not code. And one of those is that there's a definitive standard for heat. I don't have it right in front of me. It's like after October 1st, it has to maintain between certain hours a certain temperature. I would have tenants and landlords contact code enforcement to find out what those requirements are. But whatever they are, the landlord's obligated to keep it up. If somebody's bedroom is 45 degrees, although the living room may be 65 degrees or whatever the temperature is, it's still an obligation of the landlord to keep that property at a certain temperature, whatever the law says that it is. So if that requires having to do certain things to make sure that it gets a little warmer in the bedrooms, then that's what you got to do in order to fulfill your obligation under the lease. Landlords are not necessarily in control of noisy tenants in buildings. I tell people to treat it the same way as if it was the person living next door that was having the party at 3 o'clock in the morning. Call law enforcement. I would notify the landlord, let the landlord know that there's a problem with another tenant in the building of noise at all hours of the day, because the landlords want to know that sort of thing. But if the person is having loud music at 3 o'clock in the morning, you have to get up and go to work or school the next day, contact law enforcement and say that the noise is unbelievable here and I can't sleep. I got to get up in the morning. And also notify the landlord. Some have argued, I don't know that it has been tested, but some would argue that the continuous loud noises in the middle of the night and things could potentially impair the warranty of habitability. I'll get to that in a second, which is the obligation of the landlord under the law that with every lease there is a warranty assumed in every lease, which is that there's a warranty that the premises is habitable. I've heard some argue that the loud noises all night long could breach the warranty of habitability and foist the obligation on the landlord. That has not been tested, but the landlord's going to want to know. I take it this way. Most landlords, let's use 99% of landlords, 95% of landlords. Some people think that maybe it's even lower than that. But 95 to 99% are good landlords. They're good landlords. They're in business. Their house is their business. They want to get the rent. They want to keep the property up. They want to be fair. There may be one or two that are not so tenant friendly, but for the most part, landlords are good, hardworking people that want to keep their property up and take care of their tenants. They want their property kept up because they have a financial investment in the property, so they want to do that. But every landlord should know that regardless of whether it's in writing or not, the law has in it a provision that all places have a warranty attached to it, and that's the warranty of habitability. That means it's livable, safe, and sanitary. A breach of that warranty is a breach of the contract, and it would absolve the tenant of their obligations under the lease if the landlord does not keep up with it. And again, some would argue that the breach of warranty of habitability is loud music being played by some other tenants in the building in the middle of the night, night after night after night. Again, I'm not sure how that would come out if the court found that, but I think the good landlords know that if they have a 4-unit building and one tenant is causing a problem for the other 3, rather than lose out the 3 good tenants because of one, the landlord is going to do whatever he or she can to try to remedy that particular situation. But if there's out-of-control neighbor, co-tenants and things, tenants contact law enforcement, inform the landlord so that the problem can get rectified. Another issue related to landlord-tenants obligations, and that is dealing with security deposits. Let's talk about generally what security deposits are. All security deposits are a fund or pool of money that will be used to secure faithful performance by the tenant during the term of the lease. Generally speaking, what that security deposit is for the property to be returned to them, landlords, in the same condition that it was received originally by the tenant, reasonable wear and tear accepted. Meaning that there is some wear and tear that goes through the use of apartments, and that normal wear and tear is something that the landlord is already being paid for in the nature of the rent. The rent, the cost of doing business is you got to keep the property up. You got to paint, you got to replace carpeting, you got to do certain stuff over the course of the ownership. Things get worn out. It just happens. Stoves crank out. Things just, it seems like in this day and age with our modern appliances and things, they're a lot less, they don't make them like they used to. And, I'm hearing new dishwasher that you put in, although the dishwasher is not required, it's not part of the habitability, but if it's there and it's part of the rent, then it's got to be kept up. I'm told that, these dishwashers that used to last a lifetime, and they used to last 20 years or whatever, they're lasting 5 years, 10 years and crapping out. They have to be fixed and they have to be replaced, and that just seems to happen. If, however, something breaks because the tenant did something to break it, that is not on the landlord. If the tenant is smashing the stove, kicking it, or throwing stuff and breaking, that's on the tenant. And that security deposit is to help pay for damage, not normal wear and tear, damage caused by the tenant. Holes in walls that are not ordinary wear and tear should be on the tenant, and the tenant needs to pay to fix it. People can get into an argument of whether it was damage that was caused by the tenant. That's something for a judge to ultimately decide. But if things wear out, the water heater goes, that's not on the tenant to pay to replace those things. Tenants should not be obligated to have to pay to have an apartment repainted every year the property turns over, unless the tenant did something like let their kids draw murals with crayons on the walls, or some other affirmative conduct. They cut a hole in the carpeting or whatever. If they do something affirmative rather than normal wear and tear, if there's a pull in the carpet that just through normal use, instead of somebody sitting there and going like this, pulling the end of it, but if it just, it's in the common area, people's, they catch on their shoes or something and it continues to pull over a period of time, that's not on the tenant. That's ordinary wear and tear. It's something that occurs through the normal use of that property. That the security deposit cannot be used for. Yes?
If the tenant stays for many years.
If the tenant stays for many years.
Does the landlord inspect the apartment at a certain point to find out?
Does the landlord inspect the apartment? And taking your question a little bit further, is the landlord can the landlord charge for like repainting or something because the property has been used for a long period of time? Let's say the tenant has been there for 10 years and that sort of thing. let's step back. What is the normal, reasonable period of time that people would otherwise repaint? I know that I've lived in my house for almost 28 years. I've probably repainted the family room 5 times. Lots of times it's because my wife wanted the color changed, but that's a whole other issue. But it's been repainted a number of times. So somebody lives in the apartment for 10 years, and it's customary that somebody might repaint. Things get dull. You can't put that on the tenant because that's what they've paid the rent for over a period of time. I think the good standard is, unless the tenant has done something to cause damage to the wall that requires there to be repainting done, I believe that's ordinary course, reasonable wear and tear that the landlord would have to pay to redo. Same with carpeting and flooring and that sort of thing. Let's talk about the, yes.
My question about inspecting.
It was about inspecting. There's no obligation on a landlord to inspect. It's just what's the property like on day 1 and what's the property like on day 2. The question is, can the landlord inspect? And the answer is, if the parties have agreed that that's the case. And landlords sometimes flip out about that, saying, it's my property, I should be able to look. Well, here's the thing. What the landlord is being paid for is exclusive use and occupancy. That means the landlord, absent an agreement of the parties, has no right to go in and look at their apartment because they gave up exclusive use and occupancy. So landlords, if that's what you want to do, put it in the agreement that you have the right to do that. Now,
Is that true in commercial?
commercial leases will be governed by the written agreement between the parties. So the question was about commercial leases. And commercial lease is a whole different other bird. The rules are generally the same, except that, again, we're talking about in commercial leases, you're talking about sophisticated parties and they negotiate the terms.
There's no term, there's no time, they say, okay, the landlord has the right to inspect. For some reason, they missed to put in the timing every 2 months, every year, every 10 years, every whatever.
Right, there's the timing issue of inspections is based on the agreement of the parties. So so we start out with the premise, landlord has no right to inspect. Okay? They don't have the right to inspect. Can the parties agree otherwise? Yes, they can agree. And what can they agree to? They can agree to some inspection. We have another provision in the law that says any unconscionable contractual provision is, in this case, in a lease, is void, meaning it is unenforceable, it is against the law. So if we go to the level of the micromanaging landlord who says, I'm going to come every morning at 10 a.m. and inspect the premises, I can almost assure you that that is unconscionable to have that provision in the lease, and it would be thrown out. And then therefore, the landlord would have no right to inspect. So, what's reasonable? I don't know. It's what the parties can agree to. Once a year, that might be good. I don't think that's unconscionable. Once a month, getting a little invasive from what it's really what the parties can agree to. Now, there's also kind of a reasonableness standard associated with that, and that is if there is an emergency reason why the landlord has to come in to protect his or her interest in the real property, they have the right to do that on reasonable notice and at reasonable times.
What's reasonable notice?
Reasonable notice is what is reasonable.
24 hours?
Reasonable notice is what is reasonable. We can't time that. Is 24 hours reasonable? Maybe. Is 2 hours reasonable? Maybe. Is a week notice reasonable? Maybe. I'll give you a scenario why it has to be reasonable. Let's assume for the moment that it's a college residence. Let's assume that the student tenant goes home for the Christmas break. The tenant downstairs looks up and there's a water leak growing on their ceiling. Knowing there must be a leak upstairs, but the tenant's not there. Can the landlord go in? Yes. Does the landlord have to wait 24 hours to go in? No. What's the reasonable period of time? It's to go in. What I say to the landlords is, be very careful when you go in. Go in with someone. You can only go in for the immediate purpose for which you have to go in, which is, what's this water leak doing? Fix it and get out. I would say have somebody with you who can verify your presence, because I have had situations where landlords have gone in, the tenant hasn't been there, and the tenant is now claiming that certain valuable items are missing. Okay? So the question of reasonableness is very appropriate there, because it depends on the facts and circumstances. If the landlord wants to go in and change the countertops in the kitchen, is it reasonable to say, hey, I'm going to be in 24 hours from now because I'm going to replace the kitchen countertops? No. That's not a necessity. That's not an emergency. There's no, work it out with the tenant when to go in. Or at the very least, you have to wait until the end of the lease when you get the property back to go in. Now, tenants. Tenants might like granite countertops in their apartment. Be very nice when their friends come over and say, hey, look, I'm living in this place. It's got granite countertops. The landlord wants, work it out. Talk to the landlord. Say, hey, sounds like a good idea. I want to be there when you do it. I'm available whenever the schedule can be. Be reasonable about the entry. In my mind, if there's no reservation to allow you to come in to put in new countertops, you cannot do that. You cannot. It's not fundamental to the lease. The tenant may like it and want it done, and the parties can agree upon it, but it's not anything. The landlord is giving up exclusive use and occupancy of the premises. That means exclusive. That means you have no right to be there. Don't be going knocking on the door saying, I want to inspect. I want to show the apartment. No, you can't. You can't. The tenant says, absent another agreement between the parties, I have this use of the apartment until the end of December. Well, I need to rent it out on January 1st. You can show it on January 1st. Show it on January 2nd. But I need to... You have no right to get in the apartment unless otherwise agreed upon between the parties. So you might have in the lease that within 30 days prior to the expiration of the lease, if the tenant has not renewed, the landlord shall have the right to show the premise to prospective tenants between the hours of such and such and such and such on 48 hours notice. We're on 24 hours, some reasonable period of time. Then the tenant can say, well, I'm not available. I don't want the property being shown. I have a lot of valuable Well, call you get the notice. I'm going to be coming in. Give the tenant call in and say, hey, look, I'm not available at 10 o'clock. Is there a way that we can do it at 2? I'm done with class at 1. I can be there by 2. Can we work it out at 2? And landlords, be reasonable. Don't say, to heck with you, I'm doing it that day, and it's tough luck if you can't be there. Work it out. Be reasonable. If they work it out and the landlord says, look, the only time that they're going to be able to be there is at 10 o'clock. It's the only time because of other situations. Do you have a friend who can take a look? It can be there for you. Can we work it out? Try and work out something. If you can't, and the agreement is reasonable, it says right in there that it can be shown within 30 days upon reasonable 24-hour notice, and it's a reasonable period of time, then maybe the landlord will be able to go in. At least they have a better defense to say, I entered the premises under the contract. So, getting back to our security deposit issue, let's talk about the security deposits themselves. We typically think that, hey, the security deposit is 1 month's rent. And so it must be somewhere in the law that it's 1 month's rent. There's nothing in the law that says how much a security deposit is. There's nothing in the law that says a security deposit has to be paid. All it is an arbitrary number that somebody came up with that everybody seems to live by. It could be 2 months' rent. It could be Rent could be $1,000 and it could be a $1,500 security deposit. There's nothing in the law that says how much it has to be or what. But usually people have been using 1 month's rent. Sometimes people collect the first month's rent, the last month's rent, and the security deposit. The first month's rent is for the first month. The third month's rent is for the third month. And the security deposit is for the security deposit. That's just the way that it is. And whatever number the parties agree on, that's what it is. And it's used by the landlord to secure the condition of the property upon return of the premises. So there are certain rules related to how security deposits need to be handled and that sort of thing. And most questions related to the handling of the security deposits can be answered if you know the answer to one simple question. And that question is, whose money is the security deposit? Does anybody know whose money? The answer was the tenant's money, and it's correct. I don't have anything to give you for answering that question, for winning the grade. But the answer is yes. The security deposit belongs to the tenant and continues to belong to the tenant until it gets returned to him or her. So then we can ask a whole bunch of questions. If the landlord puts the security deposit in an interest-bearing account, who gets the interest? The answer is either one's. Who gets the interest? The tenant gets the interest. Why? We'll go to, I know what you're saying. Why? Because it's the tenant's money. Now, there is a provision, because the landlord is handling the security deposit, the landlord can keep up to 1% as an administrative fee. In a lot of instances, it's a big hassle, so the landlord doesn't do that. But the fundamental principle is the same. The money is the tenant's. So we ask another question. There's interest in this account. It could be handled in several different ways. It could be paid back to the tenant yearly. It could be kept in the account until such time as the tenant moves out. In our prior example, 10 years, it could be held there. It could be an offset to the rent for the last month, however much it is. The question is, who decides which one of those options is the option?
It depends how many tenants you have. That's one of the...
The answer was, it depends on how many tenants you have. Wrong again. Because we fall back to the original answer. Whose money is the security deposit? Is the tenant's money, so that the tenant decides how it's handled, except for if the landlord pays it back to the tenant yearly, then he or she's met their obligations. So as long as they give it back to within, by the end of the year, if they give back the interest. Again, a lot of instances, this is a theoretical argument at this stage of our economy, because my experience is that savings accounts are not yielding more than 1% at this stage. When the law went into effect, savings accounts were, or actually throughout the years, this has been around for eons, there were points in time where savings accounts were paying 3% or something. So that allowed for the landlord to keep some. So we had another question.
How could the tenant decide to use the security deposit for their last month's rent? Because at that point, the landlord is at risk if they damage the apartment. They've already given away their security deposit.
How can the tenant decide to get the money as an offset to their last month's rent when, in fact, the money might have to be used to pay for damages, things like that. That security deposit money could be used. I'm using the principle that there is no damage, and that it's the tenant's choice to let that security deposit account build up or keep the security deposit at whatever level it is. Okay? And again, at this stage, it's more of a theoretical argument, just simply because of that whole interest thing. But there are certain guidelines and rules. One is if the unit, if the building is more than 5 units, 6 or more, the law requires the security deposit to be put in an interest-bearing account. Requires that it be put in there. The fundamental principle also is, again, going back to our original premise. Let's assume for the moment that it's 4 units, so it's less than 6. And the landlord decides that he takes in the 4-unit security deposits and puts it in his checking account or his savings account, his personal savings account. Can the landlord do that? Okay. The answer is equivocal, and we're not going to let him be able to get away with that. He said yes and no. So why is it no and why is it yes?
Up to a certain number of units or buildings or whatever it has defined.
Now, up to a certain number of units,
You must put in a separate account.
you must put it in a separate account.
But if you have one rental only,
One renter only.
I understood that you don't have to put in a separate account.
You don't have to put in a separate account. Let's go back to the fundamental principle. Whose money is it? It's the tenant's money. The landlord cannot commingle the tenant's money with his or her own money. Cannot put it in the same account. There should be a separate, if it's going to go into a bank, it's not required to go into a bank for 4 units, for residential units in the building. If it does go into account, it can't be commingled with the landlord's own money. And I think there's a philosophy behind that law, and that is when somebody puts money in their own account, it takes on a new meaning. It's now my money. And I'm not apt to give my money back to the tenant because it's in my account. So I'm going to find some reason not to give the money back. So the legislature, in its infinite wisdom, many, many, many years ago, said, we're not going to allow that. It cannot be commingled. So, very simply, it's very easy. Just open a separate account. It can be with your same bank. Just open a separate account, and only tenant's money goes in that account. Then you're not as apt to say, that's my money.
So these are no, absolutely.
You cannot,
1 unit or 2 units.
1 unit, 2 unit, 10 units you cannot commingle.
Commingle doesn't mean to use it.
Commingle means it's putting it together, mingling it with your own money.
So plainly, the security deposit has to be in a separate account regardless.
The security deposit has to be a separate account, except if it's it's 5 units or less. It can be not in an account. It can be in your sock drawer. It just can't be with your other money. So let's take it to the absurd. I know this is crazy, but I'll just use it as a really good example. If you carry your cash in your right pocket and a tenant hands you $500 security deposit, you do not put it in with your $500, your cash, you put it in your left pocket until if you keep your cash in your sock drawer, put the tenant's money in the t-shirt drawer. Keep it separate so that it does not ever get put together so that you're more apt to give it back.
I always had security deposit in separate accounts. Still do.
Okay.
I have few still should have that separate account.
Here's the thing. He has some properties, a commercial property as well as residential property, stuff like that. You don't have to have a separate account for each tenant. You can have one account that you put all the money into. Now, if you want to make it easier, you can have one account for commercial tenants, you can have one account for residential tenants, or you can put them all together. It's just that only security deposits go in this one account. And then you keep a record of everybody's money who's in that account. And if it's bearing interest and you have to pro rata divide it up, you got to do the math. But that way you keep a record so that it's available. Because what happens is if you go, for some reason you're liquidating your properties and you sell and you go, the last tenant finally leaves and they paid a $500 security deposit and lo and behold, there's only $250 left in the bank account, you got a problem because you just stole their money. So that's how it is. Okay.
And you mentioned that the landlord can keep up to 1% of the interest.
The landlord, for residential leases, the landlord is allowed to keep an administrative fee of up to 1%.
And for commercial, the same?
I'm not talking about commercial leases.
Sorry.
It's for the residential leases, they can keep up to 1%. Okay?
Yes, sir.
If the property is sold, landlords, you have your separate account. Transfer the account to the buyer of the property. If you don't do that, although you have unloaded the property, you still are on the hook for the security deposits to the tenant. I've done, back in my prior life as a private attorney, I had done many real estate transactions, and we made sure, when I represented a buyer, I made sure that the landlord transferred the money over. Now, it could have been done in the numbers, everything's just netted out, and then I made sure my client opened up an account and put that money, because if there wasn't a separate check that was just given to my client, the buyer, that he could take down to the bank and deposit in the account, and it was in the numbers, and it netted out, he still had to make sure to take money in the amount of the security deposit transfer and put that in a separate account. Because once the old landlord transfers the money to the new landlord, the old landlord's out of the picture, and now it's on to the new landlord. So make sure that that takes place. We've talked so much about the landlord's obligations and all that. There's another person to this contract, and that's the tenant. And the tenant, although there are tenant rights, and I'm a consumer advocate, so we always talk about their rights. They also have responsibilities, and they also have obligations, and I like to also touch on those. And the very first obligation that a tenant has is pay the rent. Pay the rent, pay it on time. The landlord has financial obligations related to the property, upkeep expenses, taxes, insurance, all kinds of things. So that tenant needs to pay the rent because the landlord needs to pay his or her expenses. The tenant also has the obligation to fulfill all of his or her obligations under the lease, which is to keep the property up. The property must be returned in the same condition as received. It's got to look exactly the way that it looked when it was received, minus reasonable wear and tear. So if a carpet wears out because it's been used for 5 years and the tenants continued to reside there for a 5-year period of time, hey, that happens. But don't cause damage. If something breaks, notify the landlord immediately so that the landlord can take care of it. If the tenant does not return the property in the same condition as received, reasonable wear and tear accepted, the tenant is responsible for the damage. And here's the thing, tenants. You are not responsible only up to your security deposit. As we talked about before, security deposit is just an arbitrary number. It's just an arbitrary amount of money. If the damage that occurs is more than what the security deposit is, tenant is responsible for that extra amount. So, students, it's May, you're graduating, You're not going to have the biggest party of the year because, oh, what the heck, we've lost our security deposit anyway. You're still on the hook for any damage above what would be the amount of the security deposit. So take that into account and return the property in the same condition as it was received. It is not additional rent, landlords. The security deposit is not additional rent. You can't keep it unless there is damage and your money is owed. It's not additional rent. You got to give it back. Tenants, you can't use it as rent. Sometimes tenants will say, you have my security deposit, and I've got to go get another place, and I've got to pay the first month's rent. I got to pay security deposit, and then I got to pay you rent for my last month, and frankly, I don't have it. So just keep my security deposit as my last month's rent, so that I can then go get my new place. No. That's not what it's for. You are still obligated to pay that last month's rent, and you can be subject to eviction if you don't pay the rent. You can't go into court and say, yeah, I didn't pay the rent, but the landlord has my security deposit. Security deposit is not rent. Security deposit is to pay the landlord for any damage that occurs. So make sure you get the rent paid. Let's talk brief.
What can the landlord do to get more than the security deposit if there's more damage?
The landlord can do, the question is, what can the landlord do to get more money if the security deposit isn't sufficient? It's what anybody would do to get money from someone who caused them damage, and that is they can sue them and collect that way. Let's talk about what happens if the tenant doesn't pay the rent. What happens? First of all, landlords, you may not go personally and throw them out. You can't change the locks, you can't shut the water off, you can't shut the utilities off because you haven't received the money. You must go through an eviction proceeding in order to get the property back. Because what we were talking about is we have this agreement where the tenant gets exclusive use and occupancy. You want it back. What you need to do is have a court sever that exclusive use and occupancy and return the property back to you. You can't do it yourself by throwing things out the window, by changing locks, by turning off utilities. You cannot do that. It is against the law. You have to go to the court and have the court say to you, you get the property back. And there are certain things you must do. And if you don't do them, you have to start over. So let's go through those so to make it a lot easier for everybody concerned. Again, we're talking simply about a tenant who has not met their fundamental obligation under the lease, which is to pay. Failure to pay rent. What happens is the landlord must go through certain steps. The first step is the landlord must deliver to the tenant what I refer to as the first 72-hour notice. It's a notice to the tenant that you have rent that's due for the month of whatever, let's say the month of December. It's due on the 1st, you haven't paid it, pay within 72 hours or get out. There's legal stationery stores and there's stuff online, I'm sure, that can give you the wording for the notice. But the notice in essence says you have 72 hours to pay or get out. That must be served on the tenant. Get it to the tenant. 72 hours late, if within those 72 hours the tenant pays, it's over.
How was it delivered, the notice? Certified mail?
How is the notice delivered? I suggest personal delivery. I also suggest that it be although for the first 72-hour notice it's not necessarily required, but I would suggest someone unrelated to the landlord give the notice. That's what I best. I mean, really, it could be sent by mail, but you're delaying the mail time because the tenant has 72 hours from the time it's received. So if the landlord doesn't pick up a letter or whatever, just deliver it to them. That's the easiest thing. If the tenant pays within that 72 hours, it's over. It's done, good. But it wouldn't be fun if we had that situation, because then we could go on with our story. What happens if it doesn't get paid within the 72 hours and the tenant still resides there? What the landlord then has to do is have served legal process on the tenant, and that consists of 2 documents: a petition to get the property back and a notice of petition that notifies the tenant when they have to be in court. Okay? It says on there that it's going to be at 10 a.m. in the city court, the city of Ithaca, on such and such a day. The notice of petition is the court process. So that only officers of the court can sign the notice of petition. Landlord can't sign it, saying be in it. So if you have a lawyer is an officer of the court, the lawyer can sign it. Or you have to take the notice of petition down to the court and have the court clerk or the judge sign it. The petition is signed by the petitioner, the landlord, saying, I'm the owner of certain property, this address. Rent is X number of dollars a month. Tenant has been here since such and such. The rent is due and owing for December 1st. I gave them a 72-hour notice saying pay or get out. They have neither paid nor gotten out. I want my property back. It's much more legally formal in terms, the wherefores and therefores and all that, but essentially that's what it says. I own the property. I'm owed, the rent's $500 a month. Tenant hasn't paid the rent for December 1st. I gave the 72-hour notice on December 2nd, December 1st, December 2nd. 72 hours have expired. Tenant hasn't left. I want my property back. Now, so you have the notice of petition signed by the lawyer or the court clerk or the judge. You have the petition together. They have to be served on the tenant. Here's the important thing, landlords, very important, because you have to dot all your I's and cross all your T's. The law says that notice of petition and petition must be served on the tenant between 5 and 12 days before the day that you're going to be in court. So you got to figure out the day you're going to be in court, count back 5 days. That's a set point. You count back 12 days, that's another set point. And in that window, you have to have that served on the tenant. If you serve it 3 days before the court date, tossed out and you got to start over. If you serve it 15 days before the court date, tossed out. It's got to be between 5 and 12 days. It has to be served. It's got to be served. This definitely has to be served by a non-party. So it has to be someone other than the landlord serving the tenant. And then you have to prove to the court that it was served. Okay. So then what happens? You go to court on that day designated in the notice of petition. The tenant comes. If the tenant pays the rent, it's over. It's over, gets paid. But usually the tenant is obligated to pay the court costs as well. And if it gets paid, it's over. If, however, the tenant doesn't show, or the tenant comes in and says, I'll have it tomorrow. I had a doctor's bill I had to pay, and I had to pay it, whatever, my car broke down, whatever, I'll pay it tomorrow. Technically, that's no good. And the court will sign, it's a thing called a warrant. It's not like you're going to be arrested, but they'll sign something. It's called a warrant. It says the property is to be returned. Some courts have said, hey, look, let's hold off. I'll sign this if the money's paid. And sometimes landlords are fine with it. That's up to the court. But technically, what I'm saying to the tenants is don't have an excuse. It has.
Does the court have the right to delay that?
does the court have the right to the delay? The court does what the court does. Okay? Court does what the court does. I'm not there, nor is anyone else there to tell the judge what the judge should do or what the judge shouldn't do. I'm saying what the law says is that if it's not paid, the court shall sign, and the court, really doesn't have much discretion associated with that. That's what the law says. Now, how it works practically, we'll leave that up to how the court handles it. So then what happens is the judge will sign a thing called the warrant. It says property returned back to the landlord. Now, what the landlord has to do then is the landlord has to take that warrant to the civil division of the county sheriff, and I'm not sure how it works. I think it's different in any community. Either the sheriff prepares or the landlord prepares a thing called the notice of warrant. And that just says, attached here is the warrant. This is your notice that I will be back in 72 hours, and if you are not out, you will be thrown out. And so the sheriff's office, law enforcement, that serves that on the tenant, and the tenant has 72 hours to get out. If the tenant is not out, they will be put out at the end of that 72 hours. As a practical matter, landlords, for your own purposes, the sheriff's office does not have a posse of big guys that come in, and ladies, and starts moving furniture out of an apartment. All they're there for is to keep the peace. So what the landlord should be ready to do is to change the locks or to move the stuff out or do it. What does the landlord have to do? The landlord has to act reasonably, and I know there's that term again. What would a reasonable person do? Would a reasonable person throw the tenant's property out the second-story window? No. They just have to act reasonably. If there's a garage out back, it can be put in and stored for a little while, then there's no obligation to store it. There's only an obligation to act reasonably. If there's no other option, it can just be put out. If it's raining, hey, maybe be reasonable. If you're not having another tenant come in, you change the locks and you have a nicer day. Or if you know that the tenant's going to be back within a week to take it out, hey, is that reasonable? We all act reasonably. The important thing is to stay reasonable. That's the process for doing an eviction. And I will tell you, you got to dot your I's and cross your T's. You got to meet those time periods, and it's otherwise you end up getting tossed out of court. The important thing in this whole thing is communication. I know sometimes communication can break down, but it's very important to keep that, even if people aren't getting along that well, they still have to be civil with each other. It's still a business relationship. Try and discuss these things. Make arrangements. If the tenant's moving out, tenant, make arrangements with the landlord to do a walkthrough. Tenants, very, very important. Video the apartment just before you move in and video it just after you move out. Don't video it with your stuff in there. You want to be able to show all blemishes if you need to, so that you have video proof that you are entitled to get your security deposit returned. There's nothing better than to be able to show to the court, I'm entitled to my refund. Here's a video of the place when I moved in. Here's a video of the place when I moved out. It's in exactly the same condition. The landlord's claiming that it had to be repainted, and we needed new carpeting, and we needed a new stove, and we needed a new refrigerator. No, we didn't. He or she may have wanted new things, but I shouldn't have to pay for those. So pictures speak 1,000 words. Take pictures going in. Landlords, take pictures, take video of just before when the tenant moved in and just after the tenant moved out, so you can compare and see what the damage is and be able to base that on that, so that when you go to get your security deposit, or when you keep it and you get sued for it back, you can say to the judge, look at the place before and look at the place after. And that, I'm entitled to keep the security deposit. It does speak 1,000 words. Again, the best thing is communication, work it out, and hopefully that will give a good relationship, a good contractual relationship between the parties, and everybody walks away knowing what their rights are. If anybody has any questions regarding to landlord-tenant, I'd be glad to answer those. Our office is available. We have staff in our office. I'm in the Binghamton Regional Office, the Attorney General's office, who can contact us. You can file complaints online. You can get a copy of our complaint and fill it out. You can mail it into our office. You can call us if you have a question. We do not give legal advice. We guide people into where they can go, if they should file a complaint with our office, or however they want to do it. We only take complaints from tenants. We do not take complaints against tenants from landlords. Landlords can handle their own complaints and handle it that way. We will take complaints from tenants, or we take complaints from other consumers for other consumer-related topics. We can take complaints for the purpose of providing mediation to those complaints. We only do it in writing. You can file a complaint with our office. We have our new computer systems have availability to take complaints online. So you can fill out your complaint form and send it in, and we can forward that complaint to the business to get a response. It may not be the response that the tenant wants. We can't make the landlord or the business do what the consumer wants to be done, but we can at least try to facilitate the communication to get it resolved. I want to thank everybody for coming today. Those of you in TV land, thank you for listening. And please join us. We are here at Cornell Cooperative Extension on Willow Avenue on the second Thursday of the month at 11 a.m. We do our program at 11. And when the program's complete, if anybody wants to come in and ask me questions, as long as I'm here, I'm glad to answer them for you. Otherwise, thank you again for coming, and hopefully that you will be with us next time. Thank you.